Good morning, everybody, to our lecture series on standardization in the context of research organizations. My name is Knut Blind again, and I will now share my slides to start with. Good. Yeah, this is webinar number 4, and I'm happy that you are joining. Here, Raul today is not here, therefore I hope getting this running also without his help. Yeah, we are. Let's see. This is again, background is the EDU4Standards project, where the European Commission gave us funding to empower standardization through education in Europe. And within this context of this project, we are also running different modules. And this module of today's webinar or this pilot is addressing the EARTO community, and this activity is also now shared with the Marie Curie Alumni Association. Therefore, maybe some new participants are today with us who have been supported via Marie program. Yeah, the target groups, we are today at like webinar number 4. That means here it would have been good if at least the first and second webinars have been attended, but nevertheless I think it might also going to work, but it's getting a little bit more complex. It immediately builds on last week's lecture on research and standardization, and therefore the one other slide I will kind of repeat in order to put that in context. Next week, that means here we are now at November 27th. Next week, we have a guest speaker, and I'm quite happy to have him. Or next week here, it's Mirko Böhm. He's head of Linux Foundation Europe, and he enters a little bit a new field, the interface between open source and standardization. And in 2 weeks' time, we will talk about the geopolitics, including also the role of European interests and values. And here we have at least some input, maybe 50%, by Barbara Reiter from the University of Graz. Now, what's the agenda of today? Brief intro, and then we start with the different intellectual property rights, because I think this is probably necessary to broaden a little bit the view on this interface between intellectual property rights and standardization. However, as you will see later, especially we will then focus on patents, because this is the most relevant right, and also probably for you as researchers, it's maybe also very interesting. Also, there's some maybe commercial impact beyond that interface, which is not so strong related to the other intellectual property rights, and also some for us are not so relevant like trademarks. We also looked at different IPR policies at the SDOs, because they might differ a little bit. Then also a little bit the broader context, the legal system, and then we also look at the instrument or the type of organization which might help also to commercialize your intellectual property rights, especially your patents. That means we are looking at patent pools, why they make sense for maybe both parties. That means for the patent owners, but also for the implementers. And then we close with a little bit bigger picture, what is really the public interest, especially at this interface, and what are policy initiatives, because this is a quite dynamic field where also changes are taking place, and therefore we have to also a little bit aware of these changes. Again, we rely on this ETSI book published 2021, and in addition, there's a standard guide 39 on the role of standards and support to technology transfer, and especially integrating intellectual property rights into standards is a type of technology transfer. And here this guide gives a little bit some information on, and also has a little bit broader view, because it already addresses the topic of open source, but this topic will be kind of the main topic for next week's lecture. That means what are the objectives of today? To know a little bit the different forms of IPRs, and then especially the tensions between patents and standards, different IPR policies, at least not in detail, that's too much for 1 hour, but a little bit what are general principles, then the possible role of patent pools, and then finally also the relevance of IPRs and standards, and also what's currently going on or what might happen in the near future. Standardization is driven by different sources. We already discussed it last week. Traditionally, the companies kind of standardize because there are some requirements from the customer perspective. Cost issues, quality issues, compatibility issues might here play a role, which we have been also addressing in previous webinar series. But also the regulatory kind of impact is important, because standards complement regulatory initiatives, EU regulation, maybe also national ones. And finally, also the input from research innovation is very important, and maybe at the same level as we have seen in the first edition of the European Standardization panel. And next week I will probably share a link to this European Standardization panel, because there will be a second edition launched probably early next week, and I also encourage you maybe to have a look at this questionnaire and maybe complete it and give us your assessments. Now, last week we already mentioned patent, but we didn't really go into that. But in general, research output and innovative ideas are a subject or an object for intellectual property rights. And we also know that in standardization, many participants, sure, from the company representatives, it's understood, but also from the research side are using different types of intellectual property rights. And therefore we have to consider these when we enter standardization activities. And because intellectual property rights, I will elaborate a little bit more in depth later, they limit the usage of ideas. And that means you have to ask maybe the owners if you use these ideas, and also if specific rights and know-how is integrated in a standard, then this becomes a crucial thing and might also lead to conflicts. Therefore, it's really important to have a rough understanding of this interplay and also possible conflicts and tensions you might face. Since we are in general here researchers, we are not so into the implementation of standards. We are maybe more on the other side of those which provide ideas, knowledge, and then also intellectual property rights as inputs into standards and standardization activities. But one has to I think, just know both sides in order then maybe also to shape their own strategy. Then intellectual property rights are formal rights, and they are defined in countries or in Europe, in the regional context. In Europe we have a European Patent Office, which is the most relevant one. We have also national patent office in I think all EU member states, but they are also, especially in the larger countries, also important because property rights have always a regional dimension, but with the European Patent Office and its rules, you can address the whole EU market. And what is the reasoning? Why does it make sense to have these intellectual property rights? And there's a long history why this is established. It's about the general acknowledgement of the moral, but also the economic rights of the creators, because they make investments, they spend time, they maybe spend resources, and this is important. But an additional point is that without having intellectual property rights, maybe the investment might be limited. Therefore, a strong economic argument for intellectual property rights is the promotion of research, creativity, and innovation. On the one side, that means you are creating incentives for inventors. On the other hand, most intellectual property rights, also like patents, require the disclosure. That means a kind of a fallback strategy would be to keep everything secret. But if you want the right, then you have to give away a little bit the content, which is then helpful to disseminate the know-how. And if the know-how is already there, from an economic perspective, it makes sense to distribute this know-how and make it visible, and you can search then in patent databases for the content. These rights can also be traded. This is a little bit a new phenomena, especially in patenting. This was not the case 20, 30 years ago. Meanwhile, a significant share also of patent is traded, not only by mergers and acquisitions, when the complete kind of patent portfolio is maybe integrated in a new company, but also specific patents are increasingly traded. That means it's a barter chip. And finally, also intellectual property rights and the dissemination of the know-how might help to contribute to the SDGs, to sustainable development, because especially, for example, patents on green technologies are here important, and the broader these green technologies are used, maybe the better we can maybe tackle big challenges like the climate change. And creativity is quite diverse. We have, from a research perspective, one idea, but creativity can also be in arts and in other contexts. Therefore, we have also different intellectual property rights. And here you see an overview and of patents, copyrights, trademarks, industrial designs, and trade secrets. And they are can be used. Also, meanwhile, we have a specific regulation of trade secrets in the EU, but this is for today's lecture not so relevant. We will focus mainly on patents. Now, to go a little bit into depth, what are the different types of rights protect? Patents are focused on really inventions, and you have to apply, actively apply, and this is then examined. The utility models is also often called the little brother of patents. Again, it's on inventions, but it's not so high tech. That means you apply for it and it's registered, but an examination doesn't take place only if somebody questions your registration. Then we have copyright, which is really very broad. It's covering all creative and artistic forms, and to make it explicit, also software. And it exists automatically. That means you are not going to have to apply for it and to register. It's there by creation. Then we have trademarks. That means here the idea is not so much on protecting innovation, but protecting the distinctive kind of character of products and also services. Yeah. Patents are in general not covering services. In US, a little bit different, where they also cover software. In Europe, that's not the case. And here again, if you want to have a trademark, you might just use it. And if it's established in the market, then it's also accepted, or you have to register it. And then also designs for bottles. That means it's about the external appearance, and here you have to register. Trademarks is a very trade secrets is a very important type of right. Because it protects very valuable information which should be not known to the public. And here you can do some internal efforts. Contract issues or options are non-disclosure agreements, maybe in treaties with your employees. You could kind of include some secrecy clauses, and also what's sometimes done, you can bring maybe secret contact to your lawyer, and then you get an affirmation that you are the end of the creator at a specific point of time. This has been done previous times very often in the area of software. But in general, we do not know really much about how it's used in detail, but it's a very important strategy. For us as researchers, it's not really the preferred one, because we want to share what we have found. Now here, again, a very kind of well-established example of a complex product which includes many different rights, and the mobile phone. That means there are trademarks for the brand, for the specific product, but also for the tone. Then software is protected via copyright, but also the user manuals, ringtones, startup tone, also images. And then we have patents and utility models for the data processing methods, operating systems, operation of user interfaces. And again, depends a little bit in which country you are. It also could cover software. Then design was a very kind of hotly debated right, especially the round edges. At the very beginning was a topic where there were many kind of lawsuits. But here, designs of buttons, screens, and then trade secrets on maybe how to produce that product is maybe one important right. That means you see it's very complex. The more complex products, also, for example, think about laptops or computers, the more rights are in it. If you have more kind of simple products in the pharmaceutical sector, then patents are very important, but the other rights and trademarks, but then other rights are not so relevant. What does it mean if you have this right? It gives the owner an exclusive right for making use of the technology or the innovation. That means you can either use this innovation or the know-how for yourself, or you allow others to use it. And here you might also ask for monetary compensation. That means maybe a license, or you can also give it away for free. That's also in some contexts quite smart strategy. The rights are in general temporary. in character means patents last in general 20 years. Otherwise, have a longer period. Copyrights can even kind of last beyond the death of the author. It depends a little on the country. It means you can then exclude others. Yeah. That means even if you have the right, you might also have the need to use others' rights. Yeah? That means especially if you look at these very complex products, even if you have patents, your patents might only cover some aspects of these very complex products, and in order then to bring the different parts together, you might then also have to rely on the know-how of others, and this is then an issue to negotiate. And here, cross licensing is maybe a topic, but that's nothing. Now, IPRs and standards, our topic of today. There are different aspects, and we are not going to address all, especially the first topic here. Standards are text documents. And in general, there's a copyright on these documents, also on the PDFs, for example. Currently, there's a discussion also at the European Commission's level how to proceed with this, because there are questions of whether these documents should be made open accessible, because especially they use standards which are linked to EU law are here under pressure now. For some standards, there's the option to read them, but this is only the case for a small set of standards. But how this is going to continue is yeah, we have to see. Then some standards bodies also link their standards to specific names or logos and symbols. And here terms like GSM, Wi-Fi, Bluetooth. And here, for example, IEEE owns different trademarks. Or the GSM logo is owned by the GSM Association, or Wi-Fi is owned by the Wi-Fi Alliance. That's also to be known. For us as researchers, trademarking is maybe a little bit beyond our scope. We are in kind of mostly then related to the question when we have some inventions, some new know-how, whether we go for a patent. And then we get to these interlinkages to standards, especially when this patented know-how is part of standard. The other aspect are proprietary software code. But this topic will be addressed particularly next week when we also talk about open source software, because here the story is a little bit different, also complex, but it deserves an own lecture. Just a repetition from last week. You see here, okay, we can really then refer to yeah, these different outputs of research, scientific publications, patents, which are codifying this know-how we are creating as researcher, and this might be then considered in standardization activities, and then even eventually linked in standards. And this is the question. Now, there are different forms of intellectual property rights, and they have also different distances to the market. when we write academic publications, then they are not really relevant for the market, and at least not immediately, but they can be referenced in standards. And I introduced last week the concept of standard relevant publications. But the exclusiveness is also quite low, because in general these papers are accessible. At least the content is not protected. Maybe you have to pay for the paper. Now, when you are getting closer to the market, then patents become more important, and standards are created in order to be implemented in practice. Therefore they should be directly implementable, and also they are not exclusive. But the tension starts with then referencing patents which are relevant for the implementation of standards, and we call these patents these standard essential patents. And here then the issue is what kind of payments and royalty and licensing schemes come into play. And here the term friend shows up. I will explain later what this means. That means here you already see there's a tension. The story becomes then also a little bit more complicated if you consider that both the patenting and the standardization process are dynamic. On the top of this chart, you see a little bit the different steps of patenting. That means you file a patent, and then it's examined, and there are the options to change. That means you might amend your patent with additional information, and this can be really kind of expanded to quite a lengthy period. Good, this paper is already a little bit old, but and these processes have been reduced, but nevertheless you might talk about 5 years, and that's before then eventually the patent, the final patent is granted. In parallel, there might be standardization processes which are now down to 3 years, but nevertheless there's a high level of uncertainty at the very beginning, and we know that this uncertainty then leads that patents are then amended with new kind of additional content in order to align it better to the kind of the standard development process. That means it's really a dynamic interplay, which makes it quite complex. I cannot go further into detail, but this is just an illustration how complex this interrelation could be. That means here, to summarize again what I did last week, the standard essential patents. There's a very formalized process. I will come back to that in a minute. That means we have to declare then. It's in general linked to patent applications. Sometimes patents are granted, as you see before. It could be also the case that the whole patenting process is closed. And you do have to declare now your relevant patents. This, however, what we see in practice, partly patents are even declared after the publication of standards. It's more applied research. This phenomena is very strong in ICT. In other areas, it's not so relevant. In general, companies are the owners, but we also see more and more research organizations. Fraunhofer was also quite successful in the past with the MP3 technology. The people are quite older. The inventor, there's a strong commercial interest. That means there are companies like Qualcomm, which base their business model on really then developing patents which are referenced in standards. There might be some cost of participation, but what we know from last week is that these patents are very valuable and are getting even more valuable when they are patented in a reference in a standard or declared to be essential. It means there are also positive commercial impacts for the companies which own these patents. For standard relevant publications, the tension is not so critical. Therefore, it's no formalized process. The papers are published. They are also then fixed in a specific edition of the standard. It means here the dynamics is not as high with related to or in comparison to standard essential patents, which can be also declared after the publication of a standard. It could be also basic research. It's covering all areas, not only ICT. And here the authors are internal research institutes, universities, and also in general, older researchers are involved. The involvement is not so commercially driven, but driven by intrinsic interests. The problem is a little bit that it's not only the cost of participation in standards bodies, but also there's also a lack of recognition to be involved. However, you see similar patterns, not as strong as for standard essential patents. That means higher cited papers are referenced, and the referencing pushes the citations, but not so strong. And there's no information about commercial impacts, which we know. So, now the tension, a little bit more elaborated. It means there are different rationales for the patent systems and the standardization system. The patent system is really created to incentivize research, and it's created by a state for a specific time, and the price you pay is you have to disclose your invention. But you can then ask others to pay your licensing fees if they want to have that. Standards, in contrast, are a common platform of specification of a technology to connect, to communicate on a common base, to encourage the spread and the wide implementation of the standardized technology. It means here the intention is really the broad diffusion. Standards are only kind of successful if everybody is maybe interested or even is implemented. And the tension kind of comes up with these standard essential patents. And because here you have to find a compromise, and the compromise is the following: this so-called friend licensing. It means it should be fair. It means you should only get licensing for these essential patents, not for your whole portfolio. That means you have to really declare which patent is relevant. However, there are strategies by companies. They say, oh, everything is relevant. There is also not there should be not the requirement of a free grant back. That means that here others which are then using the standard have then to give all their patents for free to those which own these standard essential patents. It should be reasonable. That means if you think about a mobile phone, about laptops where different owners own not only a few but hundreds of these standard essential patents, if you ask then for each kind of patent a monopoly price, then the whole technology becomes too expensive, and this is then not reasonable. And now the third requirement is it should be non-discriminatory. That means in general every licensee should pay the same price. In reality, this is not necessarily the case. We know that those which own these standard essential patents, they often deal bilaterally with each kind of interested licensee, individual kind of deals, depending on the relation in the market. Is it a small player, a big player? Are these suppliers or customers, etc.? And this in reality, it's not really non-discriminatory in many cases, but it's very difficult to prove. The concept of the standard essential patents is the following. It means without the use of this technology projected by that patent, it's quite just impossible to develop a product which at the end satisfies the standard. That means you need to rely on the patent. It means you need also the permission, a license by the owner to use this this patent, which you then implement in your product, which is then complying with specific standards. If that's not the case, then you have a problem. And if you cannot get the licensing, then the only option is to invent around to create kind of a similar feature using maybe technology from somebody else, if that's not the case, then you have to stop your development. It means it's really a strong right, and the SAP owner has a very strong position. And this gets even more complicated when you have different owners of standard essential patents. Then you have to ask each individual owner related to each individual patent that you might get an access or the right to use this patent. And you might have to negotiate numerous kind of licensing deals. That's really complicated and doesn't make the story easy. And some patents might be standard essential patents. Here the QRT is not a standard essential patent. But it's a valuable patent. That means there might be also patents out there which are quite valuable, which are not standard essential. Now, how to deal with that? The standard development organizations, here especially in Europe, it's ETSI, where the telecommunications standardization takes place. They have some rules, and they have also a portal where you have to declare all your standard essential patents. And here Uli Beckert's a colleague from Eindhoven, they did a study and found in 5 years ago that around 250,000 patents are potential and essential for ETSI standards, which goes back to 25,000 patent families. Patent means that they can be also applied in different countries, but 25,000 patent companies. More recently, the company IPRs, which is now part of LexisNexis, they count more than 100,000 patent families, which are owned by very few companies. But the point is, potential standard essential patents is not necessarily a factual one. When you declare that, maybe the final kind of specification of the standard might be not really ready, and this might then change. Therefore, I have shown you previously this time horizon from patent application and standard process, and this might then change. That means only at the very end, when both the standard is fixed and the patent is eventually granted, you can make the decision or you can decide whether a potential SAP is really a factual one. There was some dissatisfaction by the European Commission about these situation, and then they kicked off different initiatives to increase the transparency, to find out what is really essential on the one hand, and then also the other kind of tension was, or the other ambition was to really make it a little more transparent what are the licensing conditions. That's has happened 5 years ago. So that's my. Here are these numbers. You see they are growing, although what we are seeing is there's a little bit of kind of a saturation taking place. It means when you have these standard essential patents, there are a list of problems. I already mentioned, okay, there might be no licenses be available. That means you have finished the standards, you published it, and then you find out that maybe there are some owners of essential patents which are not willing to license these patents to everybody, especially if these companies have been not even kind of involved in the standardization process. This might be a problem. You do not really raise the hand. You wait until companies start to implement the standard, and then ex post you come and say, hey, I have these patents and I ask quite high licensing fees, because then they are really already locked into the standard and have really a problem, and they might stop then the production of their products if there's no kind of agreement and compromise in the licensing negotiations. Royalty stacking, that means, I mentioned that before, kind of there might be many patents which are relevant, which then create a lot of licensing payments for the final end producer of a mobile phone, of a computer, maybe also of a car. And then you have to kind of consider all these costs in your final price, and this but might be quite high, and nobody in the market is then willing to pay for that. Other point is the discrimination. I already mentioned that means here they are treated differently depending on market position, market power, etc. Means that's a problem. Therefore, what has been also done is the patent offices realized this link, and what they did is then they integrated standard databases in the patent granting process. That means patent examiners are now looking at what's going on, and in some areas many search reports really then make a direct reference to specific standards. And here the European Patent Office just published in May this year a first study on this overlap, which is also important for somebody who is interested in applying for a patent and maybe also interested in entering a standardization process, because then you have to be aware that the patent examiners are looking at the documents. That means here are the number of documents the European Patent Office uses for examining patent, and you see these are 5 million documents. These are patents. These are standards documents. But what they are also using are the minutes of the standardization meetings. And this is very important to consider when you have maybe content you want to protect via patent, then you should do that before you enter standardization activities, because otherwise it might then lead that the patent examiners sees that in the minutes, and then it's okay, this is already disclosed know-how. That means that's prior art, and therefore I cannot grant you a patent. Where does this take place? That means if you are not in these areas, then the linkage is not so relevant. But the domains are wireless data networks, I mean mobile communication, data communication application, telecommunication, semiconductors, image and audio video, electronics, and then ICT, interaction and information technology. But especially in the wireless area, you have to be really aware of this interface in your patenting activities, and also when you consider to enter standardization activities. The overlap They also then linked that to the patent declared to the SAPs. There were 60,000, and patent citing SDO documents were 80,000. What they found is that in 20,000 cases, there is this link. That means these patents cite SDO documents and were also declared as SAPs. That's a study by the European Patent Office. It's a little bit discussed whether this is really at the end relevant, but you see in these areas I showed you before, there is this interlinkage, and this is important. Yeah. And the SAOs, they are aware of this different relationship or difficult relationship. And in the US, the ANSI already developed policies how to deal with that. And then in the 1980s, 1990s, there was a big discussions how to deal with it. Yeah. And then the standard development of organizations had then consultations. They drafted kind of policies, IPR policies in general, but at the end they were focused on patents. And what's also important is that they changed this policy over time, because there were new technological developments. Also, stakeholders changed. Maybe new stakeholders came into play, and this is already a further kind of recommendation. Have a look at the IPR policies in the SDOs who are active, because there might be changes. For example, next week we'll talk about open source. This was not a topic 10 years ago, but now the SDOs also address these things. And a little depending on trends, sometimes these policies are more favorable for patent owners in other contexts, or in other times when there's a pressure to make technologies available for everybody, then the rights of the patent owners are reduced. So the categories are the following. Could be commitment-based policies or participation-based policies. It means here the commitment-based policy requires that everybody who is there has to inform, to declare if they have patents which they believe they could be essential. And they also have to make a commitment about the licensing. And this is kind of relevant for ISO, IC, ITU, ETSI, IEEE. Participation policies is that if you are a member, you must be willing to license all your essential patents. That means here in general, all patents are relevant. Sometimes opt-out possibilities might exist. And this is important, and especially larger research organizations, this is also a hot topic. The consequence, if these are not given, then the SDOs in general want to start to develop standards which are not really have to rely on the standard. The licensing conditions I already explained. Fair, it means fair, reasonable, and non-discriminatory, friend or rent. There's also the options to go for royalty-free. That means if you are getting involved, then you might also ask to give the patents away for free. This is in rare cases, but there are bodies which require this. Now the legal system is observing that, and the problem is a little the following, that the SDOs themselves, they do not see that they are responsible for solving this conflict or this tension, and therefore the regulator or the government come into play. Then this goes to court. And here are some figures. Here's some figures about licensing fees in the context of mobile phones, these are the percentages we collected over time. It's a little difficult, but you see it's around 10% of the sales price 5 years ago for mobile phone went into the licensing fees. That means significant share. I've no actual figures. The other point is that there are different kind of legal areas which come into play. It could be patent law, yeah, which are an issue, then private law, which is about contracts, which are relevant then for licensing deals, or sometimes it comes also competition or antitrust law into play when especially big players are misusing this position. Yeah, and there are some landmark cases about from Microsoft, Motorola, Ericsson, Huawei, and then also more recently Nokia versus Daimler. That means there are not so many, but there are a few cases which have to be mentioned, especially when big players couldn't find a solution outside law. There are, especially in the 1990s until 2010, an increase. The reasons for that is that it became clear that these standardization patents are quite valuable, and therefore there was an incentive to really then also ask for higher licensing fees and make money out of that. Then what I also mentioned, patents are increasingly traded, and also these standardization patents. And here also new business models came into play. That means companies collected potential standardization patents and started to sue then potential implementers. They are also often called patent trolls, and that's the twin end. That means there was a commercial interest, and it also turned out that it was not so easy to solve these problems outside court. Meanwhile, these are recent figures just published this year by IPO, and you see here at EU there are not so many really court cases, 10 cases. In the UK, also a few cases. And now we have the United Patent Court into play, which is dealing with these cases. You see here. And sometimes there were settlements, sometimes there were decisions by UPC. We have to see how it's going to work further. But these kind of quite stable figures show that obviously the main players found solutions for their conflicts. Then patent pools. I already mentioned that there are many SAP owners, many implementers, and therefore the question is, so how do you solve that? And maybe it makes sense that one organization's patent pool kind of is then collecting all the relevant patents and is maybe putting them in a patent package and licensing them then out to all the interested parties which are interested in implementing these packages of patents. It means that this is kind of a little bit the simplification of a patent pool. If you have no pool, then every patent holder has to kind of deal with all the different implementers. If you have a patent pool, the number of negotiations is just, in this case, with the consolidation, just 1/3. That means this is going to simplify it very much if that's going to work. Sometimes patent pools are not getting into play because the parties are not kind of joining. It means even if there are patent pools, you as patent holders cannot be forced to enter this pool. Therefore, you could do your own thing, which might be also interesting in some cases. That means patent pools have several advantages. It's kind of this one-stop character, lower transaction cost. Sometimes also the licensing fees are much lower if you buy that in a package instead of kind of summing up all the individual deals. It also creates a level playing field because all the implementers have the same conditions, and the uncertainty is reduced and transparency increased. And for the owners, it helps to push the adoption of the technology, lower transaction costs, and at the end, you might also get higher profits, because if the pool is very successful, then they bring this technology to everybody who is interested. On the other hand, these pools could be also considered as a monopolist, and therefore competition antitrust authorities look at them, that they are not really discriminating or maybe exploiting their market power. That's an issue, but in general it works. Pools are sometimes difficult and expensive, and there are sometimes also very diverse interests, and some patent owners might really kind of exploit their patent and their monopoly power, and then therefore no pool takes place. Especially in 2, 3, and 4G, this didn't work out. But in other areas, we see pools. And here are some examples of pools. MPEG 2, then we are licensing Sysville, Modul, Avanci is now in the IoT field. MPEG-LA was also in the MP3 world very important, while licensing tried that in 3, and 4G. Unfortunately, I have not really a new picture on patent pools. It's a little bit that I kind of also not very transparent market. Public interest, that means the regulator, the governments are keen that standards are adopted and are not really create market barriers. And also the regulator is interested that there's sufficient incentives to invest in research and development and innovation, and therefore there were different activities, studies, and also then regulations. That means this at the very beginning it was more focused on the market access. That means everybody gets into. Then also abuse of licensing fees was an issue in the 20s. Especially the friend was then ignored, and then the competition policy came into play in the 2010s. In the 2020, then IoT, Internet of Things, vertical industries also were more and more kind of impacted by the SAPs, and also then the link to open source we will discuss. That means here also SAPs and technological sovereignty is a very new topic. And just to conclude, a very interesting anecdote, that means this is a proposed regulation of the European Parliament on standard essential patents, because they want to increase transparency, also to solve these topics out of the court. Then the Commission developed this proposal, and in 25 it withdraw it. And okay, we are not going to do that now. Just at the beginning of the week, it was being public that the European Parliament is now suing the European Commission because of the withdrawal. That means you see a little bit also the regulatory framework is quite dynamic, and we have to see what's going to come out of this kind of reopening this topic, because it was quite unique that the European Commission has withdrawn a regulation. Maybe it was a sign of reducing bureaucracy, because also some argue that maybe this initiative might be not successful. That was it for today. Thanks a lot for joining. As I said, next week we will have Mirko Böhm from the Linux Foundation with us, who will talk about open source and standardization, also then probably touching the patent topic again. I hope to see you next week again, and have a good time until then. Thank you.